Good morning.
Good morning.
How was the Moffat Group's event?
It was good. Yeah, they just did Patrick's Day, St. Patrick's Day little catering event.
Okay.
Yeah.
They have a good turnout?
I didn't stay too long, but yeah, it seemed to be pretty good.
Okay.
I think there was people still coming in and out as I left.
Okay.
So yeah, they had it, I think it was till 2:00. So I was there at 11.
Oh, wow. Okay.
Yeah, so I was there for like maybe half hour, 45 minutes.
Okay.
So.
Stacy, good morning.
Hi, sorry, can't find the microphone button.
All good. We've all been in that situation. Like, okay, they're either truly not there, or
Right.
they're fumbling right now with their phone, trying to, and it's they drop their phone while they're trying to switch it over. So
That was me. That was me. The latter was me.
yep, that's like I said, we've all been there.
Right.
It's crazy. Becky, good morning.
Good morning.
Glad you
How
can
are
join
you?
us.
Thank you. Can you hear me?
We certainly can. Yes.
Thank you.
We got
Yeah, glad to
Bunny
be
and Dan
here.
Dixon in the house as well.
Yay.
Nice. So, Bunny, how did the event turn out down there? Was it people-wise, was it a little smaller than you expected, or was it kind of equal to what you expected?
I was a little worried because we only had 12 people who registered, but we ended up having about probably, I would say, about 100 kids.
Good.
And at first I was like, uh-oh, because there was a farmer's market that was set up too, right there, started around the same time. But I think that only helped. And so I think it was really good. I think it turned out great.
Perfect. Well, that was, I know the one in PG, Dan, I thought it turned out actually very well. I think we ended up having the night before, Dan said, let's see, we had, I think 120 people that RSVP'd the day before, and then the day of, it was like 250.
Wow.
So
that's fantastic.
Well, yeah, it's just crazy at the last minute how many people RSVP'd. So fortunately, the event makes it pretty easy. If you don't have very many, well, I guess people are going to walk away with a lot of eggs.
Yeah.
If you do have a lot of people, then we'll have a lot of people that get a bunch of eggs, a few eggs.
I felt so bad because we had everybody there and said, we're going to start the Easter egg hunt at 10:30, have some donuts, and then around 10:20 people started getting a little like irritated, sort of. You could hear kind of people rumblings like, oh my gosh, when are they going to get this started? And so I started a little bit early and I announced it and I used my loud voice, but a family missed it. And so there was 4 little kids who missed it and I felt so terrible. So I went and bought them all Easter baskets and a bunch of stuff and took it to their house.
Oh, goodness gracious.
I felt so bad. Her little eyes were just so like she was crying and I was like, oh my gosh, I'm so sorry. I will make sure I take care of you.
Oh, you're such a good person. That's you.
Better than I am, for sure.
Yeah, well, me too, because that happened to a family as well on our end.
Mm-hmm.
That family was my client. So,
Oh no.
But
I don't know who they were or whose client they were.
They showed up late. I mean, it said 10 to 11, and we ended up, we were initially going to do it at 10:30 start, and we did a 10:15, kind of the same thing. People were getting a little antsy, but they were able to. We got them a donut, and I think we gave them like 1 or 2 eggs, whatever. But
yeah,
I thought it's so funny. Like we spent months and months preparing. We
spent 1 minute and 36 seconds.
And hours getting ready. Day of, all the coordination, all the meetings. Rob and I almost had a fight, and then day of, and it was over in 90 seconds.
Yep. Yep,
I can't believe,
Yeah.
I can't remember who said it, but it's like, yeah, it's just like Thanksgiving.
it is. It's a good comparison.
Yeah.
That is a good comparison. And the other thing I learned is Dan's not very good at riding a mountain bike. So that's what I walked away from. So
Fair enough. Fair enough.
well, good. Hey, I'm glad that glad it worked out for everybody that we're able to attend. And while we tend to end up having more people to join in a few minutes. So while we're waiting, we've got a couple of I think some good information to go over. But first off, just any wins or anything that has happened in the last couple of weeks that love to share, or that we can maybe address a concern that one of you may or may not have.
Hey, Rob, I do have a question.
Yeah, shoot.
On the ERS, is there where we talk about what the seller's willing to compensate the buyer's agent for?
Okay, section 2.
Yes. What do you recommend goes in there? So I've heard you actually put the number in. I've heard don't put anything in, and then we figure it out with the contract. Like, is there something that's wrong or right, or what do you recommend?
Great question. So first off, wrong or right, there, I don't know if I would phrase that there's a wrong way or a right way, other than this. We have to look at a couple of different things. Is when our job is to help get the home sold, right? And put the home in the best situation that can net the buyer the most amount of money. And if we put 0 in that field, then what that means is we are not authorized to communicate anything on behalf of the seller, what they're offering as compensation. So that, in my mind, that kind of hinders us a little bit. Versus if we have an amount there, then we're authorized to advise any potential buyer that the seller is open to the idea of paying X percentage. That doesn't mean that it's guaranteed that they're paying it. So let's keep numbers. Let's say that the seller has authorized us to advertise a 3% commission being given to the buyer side. Okay, well then in any communication, when people, an agent calls, are you offering a compensation? Yes, the seller is offering up to 3% compensation depending on the offer. Now, where the misunderstanding occurs is people think because whatever percentage is there, then that's the guarantee offer of compensation. No, that guarantee offer of compensation's gone unless it's handled in a separate agreement. So if we're authorized to advertise the 3%, then that's what we're able to communicate. Or let's say it's 2.5%. Okay, we're able to advertise up to the 2.5. Now, if the offer comes in and they're asking for 3, the buyer's agent is asking for 3, but we only have 2.5% in our listing agreement. What's the situation there? Is there a problem if that happens?
Well, the seller's only authorized 2.5%. So in that case, we just have to counter back, don't we?
Okay. Okay. Dan?
So I would love a little bit of commentary on how many of us are having conversations with listing agents about commission, or if we're just submitting the offer and don't kind of care what they're asking for. But I love the discussion here, because I think it's important practice versus reality, right? I have a client who, I don't want to pay him a penny, and I'm like, you know, that's kind of unreasonable, but whatever. And so if the buyer offers and part of the offer is to compensate their agent 3%, and if our contract says that the seller is only authorizing us to pay 2.5%, kind of a moot point. We're talking about different things, right? Because like the seller is saying, hey, in your communication with other agents, as other agents are asking questions about the house and whatever, like you don't tell them you're going to pay 3%. Like tell them max that the seller is willing to negotiate 2.5%. Okay, but if that conversation never happens and the offer comes in and the buyer says, hey, here's my offer for $1 million, and you know, oh, by the way, Mr. and Mrs. Seller, I want you to pay my agent 3%. We may never have had that conversation, and so that clause in Section 2 is kind of a moot point. It only directs the conversations we can have. It doesn't really have any bearing to do with what the offer is or the requested compensation for the buyer's agent.
Yeah.
So, yeah. Oh,
go ahead.
sorry.
Go ahead,
I was,
Stacey.
Dan, I would say to answer your question, the offers I've received, there's been no conversation. They send over the offer. It's always 3%. And then, you know, I do the net sheet or whatever for my sellers and we talk about it. But I agree with you. There is no conversation happening. They're basically sending it over and with 3%, like 100% of the time.
Totally.
Yeah.
I concur. I rarely.
Yeah, that's where I was going. I think that we're talking about three separate things.
Right.
There's the first question is, you know, the percentage that we put in the ERS. Again, I think it's better that we have a percentage of. I think it's better that we have something in that field, because that gives us the ability to represent that the seller is open to paying something.
So
And-
Rob, on that, if you just leave it blank, but have them initial it or whatever, then we can't even talk about it.
We don't have any authorization to address compensation.
And they just have to send it over in the offer and then we talk about it.
Correct. And so
Got it. Okay.
that's the reason why I'm not I'm not a fan of that way. And this goes back. So three things we're talking about. One is what is the issue in the contract. Two, as I said at the beginning, we're tasked with helping the client to sell the home for the seller. And if we don't set our sellers up with the right expectations, then I don't believe we're doing our job. So are there sellers that are wanting to list their home and not pay a BAC or BBC? Of course there are. Well, that doesn't mean that we don't still have an obligation to communicate with our sellers, saying, look, seller, how do you expect to find this client? I mean, do you expect them to be working alone, or do you expect them to be working with an agent?
Mm-hmm.
Oh, they're going to probably work with an agent. Well, is that agent working for free? Well, no. Okay. Well, if they're working with an agent and they don't work for free and we're not prepared to pay a compensation, that's a problem. So you need to, seller, be prepared that if they're working with an agent, there's more than likely they're going to be asking for you to compensate them in some way. Now, that doesn't mean you're obligated to, but you better be prepared to do it. And I think when we take a listing and we put 0 there, this is just my opinion, I don't feel like we've done our job as a listing agent to prepare our clients. I think we should be prepared to, hey, we're going to do this job. We're going to work with another professional, and we should be prepared to at least offer X. And so that's my take. And then the third thing about it is where I said we're talking about three separate things is I agree with you. I think most agents are submitting offers without having the discussion. And the reason why it fell in this way is because they don't want to hear that it's going to be less than what they're hoping to get paid. And now they have to handle an objection early on versus if they just ask up front. I mean, if they just put it in the offer and let the offer be the tipping point, they may or may not even have to have a discussion. So that's kind of the 3 points. Dan.
Isn't it interesting that after all the dust is settled from the NAR lawsuit several years ago now, that commissions have
Gone up.
gone up? You know, like with everything that's happened, they've gone up, and also the rate of usage of agents has never been higher. So not only, you know, so the sellers need to know these things, right? That not only, and you know, you got to phrase it correctly, but like I think the reality is there's going to be an agent on the other side, and you as the seller need to figure out how to work with that agent, and also know that all of the comparables that we're comparing ourselves to, all of these sales, they have paid an agent on the other side. So you're going to be the same, and that should be your expectation.
We just, I mean, yeah, the challenge now versus the way it used to, we knew how much commission was being paid, so it was
Right.
able to tell. But from the internal documentation, yes, it does appear that commissions have gone up, and so yeah, I'm in agreement with that. Does that answer your question, Stacy?
Yes, definitely. It helped me phrase the conversation with the seller about what putting a number in that section means. So
Yeah.
yes, thank you.
Good. Okay.
Can I address a question real quickly?
You bet, Joyce.
Dan, Dan and Rob, I don't mean to be dense, but tell me where you're getting what your source for seeing that commissions are rising.
So I know internally as my previous company and within REMAX, we track that specifically. And so as a company, we've been able to determine that our commissions have gone up.
Okay.
And I believe, this is the part, I don't have a source, but I believe the NAR has just done surveys with other companies to find out the same thing. So the individual companies have responded
Okay.
with that information. So, but yes, definitely from a brokerage perspective, REMAX and so you're using Housing Wire is what?
Yeah, I see that show up. Thank you.
So, but that's how they're going to have to get the data. They're going to have to basically ask all the independent companies or all these companies to evaluate what their average commission has been.
And
So
so,
it's not up like percentages; they're up 0.05%. But I
Okay.
think the reality is they're up, right? They didn't go down. They
But
went up.
that was
also
huge.
The
That's
usage of and then that's really the big number in
Mhm.
aggregate, and the uses of agents are going up too. So
great.
that's-
Thank you.
Thanks, Dan. Anyone else? That's a great subject, Stacy. Thanks for asking that question. Okay. That being said, I want to go into a couple of different, depending on how much time we have. I'm going to try to discuss two things first that I think will take less time, and then, assuming we have some time remaining, I want to give you guys a little bit of a look of what could be our new REPSI. Wow, how about that?
Wow.
So,
Hot off the press.
but if I do show that part, what I'm going to make it very clear, it has not been finalized. It is not official. So there are things that we discuss in it today could be different tomorrow, but at least gives you a little bit of an idea and want to just share, kind of get your opinion on a couple things. But the first question I have for you is, let's say that you have a transaction and one of the parties are either in default or, I mean, this is still a default situation, but let's say that the settlement deadline comes and goes, and more than likely the transaction is not going to close. Is it necessary to cancel that contract when the settlement deadline has already passed? If so, why or why not?
I would say technically you should. And the reason I say that is because if for any reason one side decides and they move forward and then things continue to progress, if there was an issue legally, could it be fought or challenged that you were behaving in a manner that eluded that things were good and fine?
Okay.
I guess that's a question statement.
Yeah. So I'm gonna touch on that a little bit, just in case I forget. One thing that you're discussing is called a waiver. So if I don't address it, Melissa, make sure that we get back and talk about what a waiver is and what that means or does not mean.
Okay, thank
Okay.
you.
Okay, I love that. Thanks, Melissa. So one person saying yes. Anybody say no?
I guess
Henry?
who's canceling and who's defaulting? If I was not the defaulting party, and
Say not the defaulting party.
then yeah, I would want to still adhere to the contract and make sure that I cancel properly to keep myself out of hot water.
Okay, I got Joyce. I saw you raise your hand.
Yeah, I would of course make sure that my clients fully performed, i.e. signing settlement statements, would
Okay.
have conversation with the other agent, then would issue a formal notice that our company would be retaining earnest money. And then I would do a cancellation.
Okay, Bunny.
Well, it takes at least one party to take some type of action to cancel a contract, right? Like,
Yes.
or it's never like it's still sitting out there forever and ever. At least one party has to take some type of action.
Okay, I mean, these are all great answers. Let me use a different defaulting example, and let's see if your answers change. Let's say that the buyer never deposits earnest money. Is there a contract, yes or no?
There's a contract. Is it valid?
You're still under contract. It just means the buyer defaulted and hasn't submitted earnest money. But also as the listing side, you're also responsible to follow up and make sure that the earnest money was deposited.
Okay, so
So
those are things. Yep. Okay, Melissa.
The seller, I believe, say the buyer does not deposit their earnest money. If everybody's moving forward, I feel that you could jeopardize the transaction because at any time the listing agent or the seller could come in and say, you know what, you guys didn't perform, you're under default. But I guess they could also argue, but you're moving forward.
Okay, that's the
As
same
if-
waiver. That's the same
Waiver
waiver
thing?
discussion.
Okay.
So, okay, love that. All right. So there was a couple questions. So if the earnest money was never deposited, what should the seller do if they want to move on to another transaction? Do they or do they not need to cancel the contract?
Yes.
Okay, I'm getting, yeah. Anybody believe a no, willing to take a risk? Dan's not willing to do it. He's shaking his head. Nope, not going down that road. All right. Okay. Well, believe it or not, these are questions that we get often. A settlement deadline occurs, earnest money's not deposited, so the contract is invalid. I hear that all the time. The contract is invalid. Well, let's make sure we understand what invalid means. Invalid means there was something that prevented the contract to come together. So invalid meaning I'm signing the contract with Dan's name. I'm representing myself as Dan Dixon, and I sign as the seller. Well, that is a form of fraud, which would mean the contract would not be valid. It's invalid in that situation. We never had the elements to form an actual contract. If earnest money was never turned in, first off, did we meet all of the obligations to form a contract? Were the parties there? There was no misrepresentation? consideration used to be an element. It now just the mere fact they have a contract is identified as that they have an interest in the property. But did the four corners of the contract, are those being met? The answer of that in this case, in our example, is yes. Okay, well now the buyer, they don't turn in earnest money. Well, that just means, as Savannah mentioned, that the buyer technically could be in default. And if they are in default, then the non-defaulting party, so in this case, the seller, would then have the right to decide based on one of the three options what default remedy they choose or what they want to participate in. And if that remedy is they want the earnest money, okay, well, they are going to pursue the earnest money, and now but they also need to cancel the contract to end it, to make sure that now the remedy is being issued. So they would do a formal seller's notice of cancellation based on buyer default, and therefore the earnest money technically would be there. Now, Parker, I'm seeing a little, like, your eyes are like, what the heck's going on? Or maybe you're reading something else. Maybe you're not even maybe.
Honestly, I'm listening, but I'm also reviewing a couple of contracts.
Okay, all right, that's fine. I didn't know if
I was looking at the PR on one, and I was like, "Oh, this is going to be a nightmare." So, yeah.
This exact situation right now, there is a pending lawsuit in the state of Utah where a $50,000 earnest money check was never deposited, and the seller canceled the contract and is seeking the $50,000. Well, the buyer, of course, is disputing of it. They never delivered the earnest money, but the seller is suing the buyer for that amount of money. Now, I'll be excited once. I don't know if they've settled. I don't know I haven't heard the final results on this, but it'll be great once we get something, because now we'll have an actual case study to argue this position. But the key part about it is, I'm going to share something on my screen that's going to walk through why a cancellation is necessary. And the first thing that's the question that has to come up with is, it's necessary unless your contract says something contrary. So if our contract said something like this language, that if neither party performs, then the contract automatically cancels. If it had language like that, then there wouldn't be a need to provide a cancellation, because the language is already in existence that the contract would cancel on its own. Our contracts do not read that way. Our contracts just say the parties shall perform by their deadlines. It doesn't say if they don't perform, then contracts automatically cancel. So because our language of our contracts do not say that, yes, we do need to take a formal action of what intention the parties decide to make. So let me share one thing real quick with you. And this is going to walk through with everybody the details of kind of the what ifs. So our example, everyone's seeing this right here, correct? I'll take the silence as a yes.
Yes.
Okay. So our example is, settlement deadline passes and neither party closes on the transaction. Is it still necessary for one party to officially cancel the contract? Short answer is yes, but it usually also depends on the way that the contract reads. It's definitely advisable if necessary and formally cancel and for the reason why. However, this is where the language breaks up. If the settlement deadline passes, one or two things typically occur during the contract. Scenario one, this is if the language exists already in the contract that we talked about. If a closing does not occur on or before the settlement deadline, the contract shall terminate. Our contracts do not have this language. So scenario A, it may not be necessary. Our contracts follow scenario B, where they just say the parties agree to close on or before the deadline. And because it doesn't talk about termination of the contract, this is the reason why a cancellation ends up needing to be done. Now we look at why is it needed. There's a couple of reasons why we want to cancel. Is A, or one of the key reasons is, and this went to what Bunny was kind of talking about, you're identifying what direction the party, the non-defaulting party wants to go. So, and it prevents any, I guess, Melissa, you were talking about future legal disputes. But one reason, title companies may want written confirmation that the deal is dead. Okay, great. Earnest money can't be released without instructions. We need to know what's happening with earnest money and why it's happening that particular way. So that cancellation not only cancels the contract, but it instructs the other side what default remedy in section 16 the non-defaulting party is choosing to take. And usually it involves the earnest money. In some minds, which I believe it still would be, is the property may be considered still under contract. And I would agree that it is. There's more than likely someone's in default, but we still have a contract that's in play. And then it prevents any future legal disputes, as we mentioned. So we've already talked about that. And this goes to what, Melissa, what we were talking about, is a waiver. So what a waiver is this happens all the time. So let's use the example where earnest money is not turned in. And so technically you could argue that the buyer's in default, and a week later, they finally get the earnest money turned in. But in the process, the buyer has set up an inspection and the listing, and sorry, I forgot to tell you, when the earnest money wasn't turned in, the buyer's agent notified the listing agent, the seller, so they're aware that the earnest money was never turned in. And they're like, well, we'll let you know as soon as it gets in. Sorry that the buyer was out of town. They made whatever excuse up that existed. And the listing agent said, okay, no problem. Just let us know once it's in. Well, in that amount of time, the buyer does their inspection. The seller authorizes the inspector to come in. They're aware that the inspection is going to happen. And they're moving forward. They even do some negotiating with the seller on items that the buyer wants the seller to repair. And now we're moving forward. Let's say the earnest money never gets turned in, and now they've moved past the due diligence deadline. The finance and appraisal deadline's approaching. They order an appraisal. And let's say that the home even appraises and the parties are moving forward. Well, now we get 2 days before closing. And all of a sudden the buyer decides, or no, actually the seller decides, you know what? We're going to cancel the contract based on buyer default of never turning in the earnest money. And the reason why the seller's doing that is because all of a sudden they received another offer that's worth substantially more to the seller. So rather than try to renegotiate with the buyer, they just up and decide to cancel the contract based on buyer's default of the earnest money not being deposited. If that were to happen, this is the example of what's called a waiver. What is possible in that type of a situation? First off, could the seller be in the right by offering that cancellation? Now, I don't know if there's anyone who's an attorney on this call. I'm not an attorney, but if there isn't anyone, I'm a recovering son from an attorney. So my father's an attorney. So I grew up in the household, and I've spoken many times. I mean, I speak with attorneys often. What I have learned from them is, I think the first legal term that they teach you in law school is your answer to pretty much every question is it depends. So I'm going to answer my own question by saying Is the seller in the right to be able to cancel? It depends. And let's talk about what that could be. Well, first off, if this were to go to court, and our job as agents is to prevent any potential litigation as often as possible. So we want to make sure that we're doing our job so that doesn't happen. But if it were to go to court, I mean, you're ultimately having a judge is ultimately going to have to decide that answer. And a judge, the seller can make a point like, hey, they're in breach of the contract. The contract makes it very clear. They had to do something and the buyer didn't do it. And so we're issuing our cancellation based on the contract. And a judge could literally look at that and say, that's correct. They were in breach. They never cured the breach. And so therefore, seller, you're entitled to the damages. They could make that argument. The buyer side, my guess is the buyer side would be making the argument of what a waiver would involve. And what a waiver discusses is, yes, in this example, the buyer didn't turn in their earnest money and they were technically in breach of the contract. But the actions of the buyer and the actions of the seller implied that the seller gave up, they waived their right to cancel the contract based on buyer's default because they continued to move forward knowing that the buyer was trying to purchase the home. And so the actions of the seller then waived their right to be able to cancel based on that default. And so the judge could literally say, yes, seller, the buyer was in default back 30 days ago. And had you canceled 21 days ago, you would be able to cancel. But you clearly were under the impression that this contract was moving forward. You not only authorized inspections to be done, you negotiated with the buyer and a reduction of price. The finance and appraisal came by. There were other discussions about lowering the price again because maybe even the appraisal didn't appraise for the value. Anyway, the actions that the seller were taking one after another gave proof that they weren't intending to cancel the contract. That's why they were moving forward. Only at the last minute, when a better offer came forward, that's when they chose to exercise the option of cancellation. So that's what the waiver rule implies. Was someone asking a question?
This is Brandon Bexell. The legal term for that is you've waived your right to strict adherence to the contract.
Yep. I think you may have joined after we talked about it. It's a waiver condition. Yep, you've waived your rights to that. Thanks, Brandon. Appreciate that. Does that make sense? Okay. So one thing to pick up from this, and remember, if we're in any of these situations, so let's say that I was the listing agent, and the buyer failed to have their earnest money deposited, well, then I need to have a conversation with my client, say, hey, look, right now the earnest money was due at this point. They have yet to bring it in. What would you like to do, seller? Would you like to continue to move forward? Do you want to, we don't know. Is it possible that the buyer can be in default? I'm not an attorney here. I'm not trying to give you any legal advice, but what are your actions? Are you wanting to move forward or are you wanting to cancel? If they did decide to cancel, and this is a little caveat, make sure that if you do decide to cancel because your seller wants to go another direction, that you have verified that whatever time frame the buyer had to get the earnest money not only received but deposited, that you are not canceling it before that deadline. What I'm talking about this is it could take up to an 8-day window for that earnest money to be deposited to the brokerage, because the contract says that the brokerage has up to 4 calendar days to receive the earnest money. And then after receipt, they would have up to 4 calendar days to deposit earnest money. So we would need to make sure that we are following that time frame before we exercise that option. But that is something that could be the case. And then if that's the case, we want our seller to do a formal cancellation and make a declaration what default remedy they're going to pursue. And they can do that. So that covers both things. Is the cancellation necessary? Why or why not? And then making sure that we're protecting on the earnest money. Any questions on that? Is that pretty? Or yeah, Melissa, did that answer your question about the circumstances?
Yeah, I do have a question where I had a scenario, and if I need to take this offline, I will. So you know how it's you've got your deadline for finance and appraisal,
Yeah.
and it comes and goes, and at the end, I had a scenario where there was multiple offers. This property was really being sought after, and a buyer came in kind of late into the picture and wanted it, cash buyer, close in a week. It wasn't an investor. It was just someone who wanted to buy a home for their kid. Well, and it was a lot more money. Seller would love to have taken it, right? But we're under contract. Well, at the very tail end, just a couple days prior to settlement date, the buyers come in and want to change from conventional to FHA. So just a question there, because I know that the seller was looking for an out, right? But ethically and contractually, what can a seller do? Like, is that an opportunity for them to cancel? And is that okay?
It's a great question. And does anyone want to add anything to that or take a shot? Or do you want me to just come out and go swinging?
Go swinging.
Go swinging. All right. Well, this one is a little bit more unique because by going from conventional to FHA versus FHA to conventional, FHA requires both buyer and seller to agree in order to do that. So because you went from conventional to FHA, the buyer doesn't have the right unilaterally to go that direction without authorization from the seller to participate. The buyer can try to seek financing from some other avenue, hard money, another type of loan that's available that would not be an FHA or VA loan. But because the VA and FHA loan requires authorization from both parties, that's where they would be jeopardized. So in your example, if the buyer did not qualify to go any other route other than FHA, well, in that example, then they would want to cancel to prevent them from being in default. If they didn't cancel and they went past the financing and appraisal deadline and then all of a sudden couldn't qualify, well, then what's going to fall into play in that case is that the contract would say that the earnest money would be the only defaulting remedy. So your seller would be able to get the remedy that way. But let's say it was in reverse order, where initially your client or the buyer was going to go an FHA loan, and they chose, and the seller was okay with that. They chose that direction, and then all of a sudden they qualified to go conventional, and they chose to make that change from FHA to conventional. Well, the buyer could make that change without any authorization from the seller, and it would be fine. Now, the only part that might be that you would, if you went that direction, the only caveat I would make sure that you caution, if you are the buyer, if you were the buyer asking the seller for closing costs in the FHA addendum, and that's the only place that you put the closing costs, and then you decide not to go FHA, you go conventional, well, you've got to, my opinion would be, you don't have an agreement for closing costs anymore because that agreement applied to the FHA only. You would want to make sure that you had the closing cost addendum in the actual contract to offset it otherwise. That would be the only caution that I would throw out to you going that direction. Did that answer your question?
Yeah, it was it was sticky there. The buyer agent was really upset. We ended up sticking with them. But he was really upset when I said, you know, the seller could potentially cancel, or, you know, that I guess the buyers are in default, and he could have gone with this higher. It would have netted him 20,000 more. Is that
well? The buyer wouldn't be in default until they just didn't perform. So be careful with that, because they still have until settlement deadline to arrange their financing.
Oh, okay, that's good to know.
So they're not in default until they can't perform.
Okay.
So that's why I'm saying they could have gotten a hard money loan. They could do whatever they need to do in order to perform. But if they don't qualify for a conventional loan, they got to find something else out. And your seller would have had the right to just not authorize that. Nope, we don't want to go FHA. We don't want to go VA. Okay.
Interesting.
Dan, you're muted.
Sorry. Got an interesting one here for you. We represent the seller and pulled title, did all the things you're supposed to do. Went to the seller, and seller said, yep, I know these loans and looks good. We get all the way down, 28 days into a 30-day contract, and the seller says, oops, I owe a lot more than what's on the title report. And so the seller can no longer perform on selling the property because they don't have the money to pay off all of the debts at closing. And so earnest money is $3,000. And so the buyers, we said, okay, well, I guess we'll accept $3,000 as liquidated damages from the seller to cancel this contract. And the seller says, I don't have $3,000. And so now the buyer's up a creek without a paddle. Fun times.
So are you asking how do you handle that? Or are you asking just trying to share a story?
I'm sharing a story, Phil. I mean, there's probably a lot of, gaps there that you would need to really create a lot of commentary, but what commentary do you have, just generally for that, kind of scenario?
Yeah. So the first thought that comes to my mind is, first off, is the seller in default, and contractually does the seller have an obligation on behalf of the buyer to fulfill the contract? And if they don't, then there are default remedies outlined in the contract. And the three are either the earnest money, sue to perform, or sue for whatever liquidated damages that they have. So in this example, based on what you're telling me, it sounds like the seller was in default. And if the seller does not willfully pay up with what the buyer in essence is asking. So in this case, it sounds like the buyer was asking for option A and the seller said, don't have it. Okay. Well, this is where, even though the seller may be in default, if the seller isn't going to do anything about it, our only recourse is to either walk away or try to negotiate something better, or go to court and make the court force the action. So we're talking $3,000. It's a small claims court amount. And could your buyer, do they have the right to go to small claims court and find out for sure if they have money? Maybe they don't. I mean, if they don't have any money, then it's wasting their time and everybody else's time. And so now this is, in my opinion, it's whether or not you believe that they have money or not. If they truly don't have money to come to the table and they're going to have to do a short sell, it's probably not likely that you could go to sue for performance, because they maybe don't have the right to do it because they're in default. I'm sorry, they're upside down on their house. So that's probably not an option that you'd want to pursue. So then, to save everybody time and effort, even though it's not necessarily right, maybe they don't have $3,000, but do they have $1,500? Do they have 1,000? And this is where the negotiations happen, because if the buyer doesn't want to make the effort to go to small claims court to get $3,000, but they're willing to walk away for $1,500, then see where that negotiation happens. And then in that case, now you're going to say both parties mutually agree to cancel the contract in the event, and seller agrees to compensate the buyer in the amount of $1,500, and use the earnest money dispute resolution form to offer the additional waiver. So those are the ultimate remedies. But you're right, just because a party's in default doesn't mean they're going to get the money, because they may have to go to court in order to make that happen. And it's not always that easy.
Interestingly enough, the agent on the other side said, "Hey, my broker said sometimes the listing brokerage will just pay for the seller's earnest money deposit," like basically trying to ask us for it. And I was like, "Well, not this time. Maybe sometimes, but not this time."
Maybe if the listing brokerage had, or the agent had something to do with cause the problem.
That's right.
I think it's important. Oh, sorry. I'm just going to say, I think it's important whenever I meet for the first time with a seller, I always ask them what they owe on the house. What's their payoff on the house, so that I know their financial situation and their payoff up front. So I know how we need to navigate as far as what price we're going to be able to get for the house, and can they pay it off, and with the selling costs. And so we have a clear picture of their financial situation in the beginning.
I agree with you, Carrie. Making sure that that a net sheet is done at the beginning, especially, it's also for your protection. You can say, "Hey, look, we went over this, we covered this." Well, you failed. All of a sudden, they forgot that they had some other outlying debt that they thought they were honest with you about, but now they owe another 30, 50 grand somewhere else that came up. Well, now you can show that, well, we didn't talk about this. You never let me know about this. And that certainly does happen, but absolutely do a net sheet. Okay. And we got a few minutes left. Is that 10 minutes? Okay. You want to see a little bit of the REPSI? Dangle the carrot, a little bit of that?
Yes, yes.
Okay, because we're not going to have enough time to dive into the meat. And then the other thing that I wanted to talk about, we can postpone that a little bit more, but let's show you a little bit of what is in store. And I'm going to ask one primary question that I honestly want to get your opinion on, because it'll be helpful to determine if we're moving in the right direction. So, okay. First off, the key thing, the big difference about what we're doing on this contract is we're taking everything in our current REPSI that deals with dates, deals with monies, deals with assessments, deals with warranties, all this other stuff, things that you input into the form, and we're putting that on the first 1.5 pages. So now, right out of a glance, you can see everything that applies to the contract. So this section, of course, we always had the loan terms that were on it, the purchase price, the earnest money, and the offer. That part is kind of the same. But now we're putting things in different places. So I'm not going to go into the earnest money section here, but right here, here's your compensation right on the first page. Is there compensation in the offer that the seller should know about? I mean, we're basically trying to make it more transparent for the parties to see. Everything on this first page are things they need to be aware of. So compensation's on the first page. Section 4, these are your key deadlines, your due diligence. Is it conditioned upon due diligence? Check the box if it is. Is it conditioned upon the appraisal? Check the box if it is. Is it subject to a home selling? Check the box if it is. We're going to change this one a little bit differently, but same thing applies. Dates, seller disclosure deadline, due diligence, appraisal, settlement, and possession. All of this stuff is on the front page. And so now there's nothing hidden in the contract of things that you should be aware about. Included items, things that are included, those are things that are there. So my first question for you is, what are your thoughts on having everything that we put into the contract pretty much just on the front page? Do you like that? Yes or no?
Love it.
I like it, but I have to memorize all my sections again.
Yes, that's everyone's going to have to do that, and myself included. So that part I'm not excited about, but yes, that's unfortunately the consequence by making this change.
It looks so much cleaner. The conditions of purchase is a financing condition there?
That's a great question. I was hoping that you were going to bring that up.
Oh.
Do you see a financing condition under deadlines?
Nope. Or the number 4.
Correct.
Section 4. No, I don't see. Yeah.
So that's the question that I want to ask you guys. We go down to section 12, which is our old section 8. This is where it has due diligence, appraisal, and then the subject to sell. What you're going to see here is we removed the financing condition. And this is the reason why. I'm a big fan of the way that we currently have it, where it has the 8.3 BI in the contract that just says, hey, if they cancel after due diligence but before financing, here's some skin in the game. Well, we've looked, that section is rarely ever used, and it blows my mind.
I use that section on every contract that I write and have for years. Is that section going to be in here, or are you just saying our industry sucks as a whole? And so we like, what are we doing here?
Remember, here, my disclaimer again. This may or may not be what is actually decided upon. I'm giving you a taste of what it could look like. As of right now, this is the way it is, but we may go back to the way it currently is. The way that this is, Parker, the 8.3 BI is gone. There will not be a financing condition, is the way that this reads. There is only a due diligence. And the reason why the majority of the people do not use 8.3 BI, and what happens is it ends up creating this false sense of security for sellers, and a bigger opportunity for a buyer to cancel at a later date based on financing with no additional consequence. So what we discussed is, look, if we, instead of having 2 deadlines, a due diligence and a financing, let's have one deadline. And as you can see right here, this language right here, this is the terms of the loan are under the due diligence section. So we know that by having only one deadline, you're going to more than likely, due diligence is probably going to be extended a little bit, and financing is going to be shortened a little bit. So hypothetically, if a standard contract deadline in today's contract has a due diligence of between 10 to 14 days, and a financing deadline is between 21 to 24, then this could mean that now due diligence, the deadline that we put here, in the contract, instead of it being 10 or 14 days for due diligence, it may need to be like 18 or 19 days. So we're basically giving some more time for due diligence, but also we are shortening the time for the finance and appraisal deadline. So my first question, and
Yeah, but Rob,
yes,
that section is twofold, right? That we're talking about eliminating. One, what it does is it really tests the grit of the buyer, right? Because the buyer's not willing to risk any money, they're not going to proceed with the contract. So it actually,
well, then they're not going to buy a house.
yeah, but it also fast tracks the contract in such a way to say, well, we got to get our due diligence done in 10 days. So it helps the seller know, okay, these guys are serious, they're ready to push it forward, and there's additional skin in the game. So my question is why can't I just take what's currently in the REPSI that we have and just put it as an addendum?
Well, it's not because it's not being used. I mean, you're right. If people were doing it, if your seller were to say, hey, we're not going to make this condition upon financing, you could certainly do that, but that's not what's happening. And also, we've looked at contracts from other states to see what they are doing as well. And we have seen other states go this direction. That doesn't mean that it's the best decision. That's why I'm coming to you guys and wanted to get your thoughts. Before I get the thoughts real quick, because we're running out of time. And maybe we just stew on this for a little bit, and I bring this up in our next contracts class, and we can go in a little bit deeper, but give you something to think about. And maybe that's the better thing is this is what I want you to think about. First off, the pros and then the cons. The pro is what it's going to force us to do as an industry. It's going to force us to make sure that our buyers are truly more prepared. We got to get them with a lender, get them more serious, buying into the fact that, hey, you guys, you don't have a lot of time. Before we start looking at homes, you have got to make sure that you're get your financing in order so that you can actually perform. Because otherwise, you're not going to have a lot of time to get all this stuff done. It may force parties to really not just get pre-approved with a letter, but truly give their information. I'm going to stop sharing this at this point. Truly meet with the buyer, have a lender meet with the buyer so they are truly qualified. I see that as a good thing. That is, we're not wasting sellers' time, we're not wasting our time, we're not wasting the buyer's time. If they truly haven't gotten with the lender and gotten pre-qualified, then this helps promote that. What it can also do is Parker, kind of is what you alluded to, is the fact that it helps a seller know that a buyer is more serious or not. I mean, they don't have a lot of time to do it. Now, some of the challenges with it, and I agree with this, is oftentimes when we get before we order an appraisal to save our buyers some money, we want to go through the due diligence. We want to make sure the home meets the condition that the buyer wants to move forward with before we order that appraisal. Well, if we're not quick on getting those inspections ordered, or depending on the test, it could take a little bit of time, that could jeopardize the buyer's timeline to be able to get their loan approved. So that's the negative side of this. But I do like the fact that we're making things a little bit simpler and more concise moving forward. But I want you guys to maybe stew on this until our next time we meet, and we can go over this again and really go into more detail, show you what is things that are different. For example, here's a little nugget on included items. Guess what? We've included a home automation section. We got smart houses now. So our things that we have to ask are totally different than what we have been doing. So there's things on this contract that are, I think, incredible. But I still want to get a little bit more information from you guys and what your thoughts are. So is that fair? Just be thinking about whether or not you like the idea of having only one deadline between the due diligence and financing, or if you prefer the two, I want to hear whys and whys not, why nots, whys nots. I want to hear why nots in our next time we meet.
May I suggest you put together some sort of questionnaire as well and maybe send it out for us to answer?
Hey, that's a
Since
good idea.
You've seen it, we haven't, other than just small little things. So you can say what are some of the changes that are going to be made. How do you feel about it?
Yeah, and that's what I'll do. I'm not going to go into in depth with everything because just can't do that. But
I'm not asking you to do that. I'm just saying maybe you just summarize the key 5 or 6 changes and say, how do you feel about it? Here's what it said and here's what it's going to say. How do you feel about it?
I think that's a great idea.
It's hard to give you feedback after 5 minutes of looking at just a couple sections online.
I totally get it. That makes sense. I think it's a great idea. Thanks, Clint. Okay. Well, I appreciate everybody being here, and we will look forward to seeing you on the next one. See you guys.
Thanks, Rob.
Thank you.
Thank you.
Thanks, Rob.
Bye.